Two examples. Following a breakdown in communication between the parents and medical professionals over an experimental treatment for mitochondrial disease, Mr. Page. These are just two of a number of cases where there is a disagreement ends up in expensive and intensive court proceedings where judges have to make what should be an ethical decision about medical treatment. This is a fundamental flaw in the system that this bill tries to remedy. And it's clear to me that we do not have the appropriate support mechanisms in place to bring parents and doctors together at an early stage where there are disagreements about treatment and to properly address difficult questions which may very well prevent these long, stressful and expensive court cases which are harmful to the child, parents, doctors and the hospitals. In recent months, I've met with Chris Gard and Connie Yates, the parents of Charlie, who tragically and in highly public circumstances passed away on the 28th of July 2017. Charlie was born with a rare genetic disorder, MDDS, that causes progressive brain damage and muscle failure. Following a breakdown in communication between the parents and medical professionals over an experimental treatment for mitochondrial disease, the hospital and Charlie Gard's parents entered into a lengthy and distressing dispute involving a series of court proceedings. The case went to the High Court, the Court of Appeal, Supreme Court, and even the European Court of Human Rights. The case was painful for all involved, the parents, the medical professionals working at the hospital where Charlie Gard received his treatment, and everyone else concerned. The case clearly illustrated problems with the current dispute resolution systems. The court proceedings caused enormous emotional harm and stress to both parents and medical professionals. Both wanted to do what they thought was best for Charlie. Instead of a smooth and efficient process aimed at resolving the conflict, what we saw was a huge entrenchment and precious time lost when Charlie's health was deteriorating. Worse, parents and medical professionals were pitted against each other in the full glare of media, and this helped no one. Since then, Connie and Chris have dedicated themselves to preventing the escalation of conflict and protecting the doctor-patient relationship. These conversations and my observations of a number of similar cases have led me to table this bill, and I'm pleased to say that I have support from honourable members from across the House, as well as doctors, including medical ethicists and former presidents of the British Medical Association and the wider public. Organisations such as the Medical Mediation Foundation are already active in trying to resolve disputes between parents and doctors in various medical settings. A study by the Centre of Health Economics from the University of York also shows that as well as saving time and taking the stress out of disputes, mediation could also save trusts money by resolving issues concerning treatment quicker and without the need for expensive proceedings. Broadly, the bill does 5 things, all geared towards addressing disagreements quickly and clarifying the legal situation so that cases are less likely to end up in court. First, it requires the Secretary of State to put in place measures to improve early access to mediation services in hospitals where conflict is in prospect. Mediation has been proven to be an effective way of re-establishing trust between parents and doctors and helping them work together to make the best decision for the child. But currently, access to and take-up of mediation services is very low. Second, it provides access to appropriate clinical ethics committees so that both doctors and parents can be supported in making difficult decisions by impartial ethical experts. Very few hospitals have access to medical ethics committees, meaning that parents and doctors often face a postcard lottery when looking to get the appropriate ethical advice. This bill would put a provision in place for committees to come together quickly when required and ensure that doctors and parents do take the step of calling for a committee at an early stage when they're faced with difficult decisions. Third, the bill would provide the means necessary to obtain second medical opinions swiftly, ensuring that when requested, parents receive access to the child's full medical data so that those second opinions are fully informed. Fourth, it seeks to provide access to legal aid to ensure that families are not forced to employ costly legal representation or rely on outside interest groups in order to fund representation in the courts. Finally, the bill would create a new legal test of whether an alternative credible medical treatment could cause a child disproportionate risk of significant harm in order to decide whether a parent is able to seek that treatment for their child. This test would replicate the legal test already used by social services, considering whether to remove a child from their parents' care, and would sit before rather than replacing the current best interest test, which is very broad and can be subject to a number of different interpretations. The clarity brought by this test would in turn bring more certainty around the legal outcome of a legal decision, and therefore prevent cases from ending up in court. It is my view, and the consensus view of medical ethics, that if a treatment is not harmful and reputable doctors are willing to provide it, that no one should be prevented from seeking this treatment, and the new test of disproportionate risk of significant harm aims to clarify this. Most of all, the underlying aim of this bill is to prevent conflict between doctors and parents and help support them as they work together during the very stressful and upsetting situations. Conflicts are bad for doctors, they're bad for parents, bad for our NHS, and bad for the children whose care is under consideration. The frequency of these cases and obvious distress it causes all parties have led me to believe that the legal system in this regard is in desperate need of reform. I hope my parliamentary colleagues will agree with me on this. I commend this bill to the House.
The question is that the honourable member have leave to bring in the bill. As members of that opinion, say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Who will prepare and bring in the bill?
Seema Malhotra, Emma Hardy, Sir Roger Gale, Preet Kaur Gill, Ruth Cadbury, Brenda Sharma, Sir David Amos, Tim Loughton, Kerry McCarthy, Kate Holland, Tayo Owotemi, and myself.
Bambos Charalambous.
Children, Access to Treatment Bill.
Second reading what day?
Friday, the 27th of November.
Friday, the 27th of November.